The Supreme Court hears the latest clash on religion and gay rights. The Supreme Court's conservative majority sounded sympathetic to a Christian graphic artist named Lori Smith from Colorado, who objects to designing wedding websites for gay couples, a dispute that's the latest clash of religious rights versus gay rights, and to the land of the highest court it goes. The designer and her supporters say that ruling against her would force artists, from painters and photographers to writers and musicians, to do work that is against their beliefs. Her opponents, meanwhile, say that if she wins, a range of businesses will be able to discriminate, refusing to serve black customers, Jewish or Muslim people, interracial or interfaith couples, or immigrants, among others. Over more than 2 hours of spirited arguments, the justices repeatedly tested out what ruling for the designer could mean, using detailed and sometimes colorful hypothetical scenarios. Those scenarios included a black Santa asked to take a picture with a child dressed in a KKK outfit, a photographer asked to take pictures for the Jewish dating website JDate, and also the marital infidelity website Ashley Madison, and a food business called Grandma Helen's Protestant Provisions. Where to draw the line for what a business might do without violating state anti-discrimination laws was a big question in Monday's arguments at the High Court. 20 mostly liberal states, including California and New York, are supporting Colorado, while 20 other mostly Republican states, including Arizona, Indiana, Ohio, and Tennessee, are supporting Smith. And it's an interesting standard of what the court heard. If I was going to bet $20, we're going to hear probably a 6-3 decision for the graphic designer, the website designer in Colorado. But that's interesting because no time in modern history in the last 50 years would you come to this conclusion in the Supreme Court. It is only because of what happened with Donald Trump as president from 2016 to 2020 that this moment could happen. That's the only reason, in my opinion. The other interesting but it is what it is. Elections matter, and they got what they wanted. The other thing that is interesting is when it comes to the court applying equal protection under the law kinds of standards like this case does, I go back to 1958 and apply the exact same standard. If there was website designers in 1958 or cake bakers in 1958, I am not going to design a website or bake a cake in 1958 for a black person. And I wonder what the Supreme Court would say. In 1958, they might have upheld that. By 1964, they wouldn't. And for the next 50 years, they wouldn't if that was continually challenged. I see absolutely no difference here. And the hypotheticals that they gave were exactly in these scenarios. They're trying to carve out exceptions to be able to discriminate. And that is clearly what is going on here. And we should prepare. That is clearly probably what we're getting ready to accept.
Well, one of the reasons that the hypotheticals are happening is because there really is no defendant in the case. So was news to me. I didn't know that the Supreme Court would actually hear a case where it's just a hypothetical. So that begs the question, are they choosing this case because they don't choose most of the cases that are brought before them?
What do you think?
I think it's that they're trying to set a precedent in case law so that they don't have to rule on any other LGBT case that comes before them that has to do with this, that they can say, well, you know what, it's going to take the heat off of us. The lower courts are going to decide with whatever it is that we set as precedent right now.
It would have been an interesting escape clause out of 1958 to 1964 if the courts would have done the exact same thing. That's a super interesting point.
But also, you know, I may be a little different in that as an artist, I really don't want to be compelled to support something or to perform or to create for something that I don't agree with. So if the KKK wants to hire me for I don't know, one of their recruitment events, of course I'm going to say no to that. And because I'm in a service art-based industry, I can do that. And that's also what the Colorado law says, as for what I understand, is that it does not compel artists to have to perform for causes that they don't support. However, it's, they never ruled on it with the cake baker, what is the difference between selling a product in your store that you can just turn somebody away versus whether you have to create some kind of artistic expression. And because that case was not decided, it was decided on a technicality. It didn't address the question. So now we're here, and the courts are going to address that, and we'll see what they say.
Yeah. Well, I mean, the horror is that once again, Clarence Thomas, Samuel Alito, and of course, the Trump picks Gorsuch, bedwetter Brett Kavanaugh, and Amy Coney Barrett, they're going to be making decisions that are going to have lasting impacts
for decades
on us, our community, forever.
Yeah.
I mean, that's just, it's horrifying, really.
Yeah. LGBTQ plus news is vital for our community and for the broader world as a whole. We have enough enemies at Fox News. Tucker, Sean, and Laura are loud. We need passionate allies. Happening Out Television Network, Queer News Tonight, and It's Happening Out are literally out of the closet and into the headlines. Our community needs your support. Like this broadcast and subscribe now to ensure the growth of the entire LGBTQ plus community.